Thank you. You may be seated. You may resume your cross-examination.
Thank you, Your Honor. Good afternoon.
Good afternoon.
All right. Just a couple quick follow-up questions. With regard to exhibits 44 through 48, and that
Yes.
is the rainbow vacuum cleaner.
Yes.
You said that there was liquid in the canister,
There was liquid in the canister portion, yes.
and this is a type of vacuum that uses water and chemicals to clean.
I don't know.
Have you ever examined a vacuum like this before?
No, this is the only vacuum I've examined as part of my job.
Now, you did a pretty thorough job on all the parts of the vacuum itself. There was the canister itself, there was a hose with a wand, there was floor cleaning attachments, black and gray, a brush, and an attached bottle. You
Yes.
examined all those for blood.
Yes, I tried to find any blood, anything that would test positive for the possible presence of blood, and I did not find anything.
And then you went further to try to find out if you could get any DNA to determine maybe who was the handler or the user of this vacuum.
Yes, so I did swab one of the parts. Sorry, which part it was. It was Exhibit 45, which is the vacuum hose with wand attached black. So that's the actual hose part that someone would actually, what looked like it would handle, and has a little trigger. I think it had a trigger, I don't recall, but it looked like where it would actually be handled. So I did swab there for any potential touch DNA to get off of that item, and I was not able to obtain any DNA results from that swab.
Now, with regard to blood being on items that you examined or on swabs, there's no way to date that. You can't date when blood is placed anywhere, can you?
Correct. There's nothing in my testing that can tell me how or when blood got on an item.
I want to ask you a couple quick questions on the Fila T-shirt.
Yes.
You couldn't determine who the wearer of this Fila T-shirt was, could you?
Correct. I did collect a swab of the inside of the shirt, but to potentially determine any DNA from the person who was wearing the shirt, and that results from that swab was too limited to be able to make any comparisons.
And I want to go to your January 9th report really quickly on page 2.
Okay.
And as I was running through the list, I want to make sure I covered everything. Exhibit number 203, the liquid contents of the kitchen sink drain trap. 2 vials, no blood was found.
Correct.
And also exhibit 197, a men's dress shirt, which is gray and black with blue and silver pinstripe from a top of a washer and dryer. There was no blood on that.
Correct. That was also negative for blood.
And lastly, exhibit number 198, a men's dress shirt, which is purple, also from the top of a washer or dryer. There was no blood on that.
Correct.
And it's your understanding those came from 317 Covent Gardens.
I have no idea where those came from.
Thank you.
All right, thank you. Any redirect?
Mr. Gargone, I know that the defense has gone over a number of other items, including some items that we didn't discuss earlier. But just to be clear, the 4 swabs that you received identified as coming from the master bedroom closet, all 4 of those tested positive for blood. Is that correct?
Correct.
And 3 of those matched the DNA profile of Talia Otto.
3, 1, 2, and 3 did, yes.
And of the 13 swabs that you received from the master bathroom, all 13 of those tested positive for the chemical indications of blood, and all 13 of those contained DNA profiles that matched Talia Otto. Is that correct?
All of them tested positive for blood, yes. 13, yes. All 13, I did get either a complete or a partial DNA profile that matched Talia Otto.
Okay, so that would make 13 swabs that matched the DNA profile of Talia Otto, correct? So far?
13 plus the last 3.
16.
16.
16 so far out of those. And then of your swabs from the the Honda trunk mat, of the 4 areas that you swabbed, 2 of those tested positive for blood, and, well, all of them tested positive for blood, correct?
Correct.
And 2 of the 4 came back with profiles, 2 of the areas came back with profiles that matched Toledo Auto, correct?
One of them did.
One of them.
Just E.
Okay. And so that makes 17 swabs, correct, that not only tested positive for blood, but had a profile that matched Toledo Auto. Is that right?
Yes.
And then the garage door clicker, that had the defendant's, Toledo's DNA. It matched his DNA profile, correct?
Yes, the DNA from that matched Luis Toledo.
And with regard to the Black Van Heusen T-shirt, you could not exclude him from being a contributor to the DNA profiles found on that shirt.
Yes, I could not exclude Luis Toledo from that mixture.
Nothing further.
Thank you. Any recross?
Yes, Judge. With regard to the last item where you could exclude Mr. Toledo from the Black Van Heusen T-shirt, there's also the language you use in your report that you couldn't include him either.
Correct.
It's neither nor, correct?
Correct.
Thank you, Judge.
Okay, any redirect?
You were able to exclude Shawn Jackson, correct?
Correct, I was.
Any recross? All right, thank you. Any additional questions for this? I mean, can we excuse him from the subpoena?
Yes, Your Honor. Yes, Your Honor.
All right, thank you. You're excused. State, call your next witness.
The state calls Shawn Johnson. I do.
You may proceed.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you introduce yourself to the jury?
My name is Shawn Michael Johnson.
And Mr. Johnson, how are you employed?
I'm employed by the Florida Department of Law Enforcement out of the Orlando Regional Operations Center in the Biology DNA section.
And what do you do in the biology section there in Orlando at FDLE?
I'm a senior crime lab analyst, and my primary duties are to examine items of evidence for body fluid stains such as blood, semen, or saliva. Once I identify those stains, I then perform DNA analysis and try to determine a possible donor of those stains.
Okay. Now, we just heard from Anthony Gorgon. Do you know Mr. Gorgon?
I do. He's my supervisor.
Can you just briefly describe your education training as it relates to this particular field?
Sure. I have a Bachelor's of Science degree in biochemistry with a minor in chemistry, and then completed the training course through FDLE that involved conventional serology, which is the identification of body fluid stains, and then the training that involved DNA analysis.
And how long have you worked for FDLE in this capacity?
I've been with FDLE for 20 and a half years.
And can you approximate how many times in the course of your career, and again, approximate would be the operative word here, how many times you have performed forensic DNA testing on items of evidence that come into the lab?
Approximately 15 or 16,000 samples.
Have you ever testified before as an expert witness in the field of forensic DNA analysis?
Yes, I have.
And approximately how many times?
Today would be my 145th time.
And are those jurisdictions throughout the state of Florida?
Yes, they are.
Now, we've already heard from Mr. Gorgon in terms of the basics behind DNA, so we won't get into that with you. But what I will ask you is, were you assigned to conduct some DNA testing in this case involving an investigation involving victims by the name of Yesenia Suarez, Michael Otto, and Talia Otto?
Yes, it was.
Okay, and that was in January, February 2015?
Yes.
Now, I'll ask you, just like I asked Mr. Gorgon, is it fair to say that you tested a lot of items in this particular case?
Yes, it's fair to say.
Okay. Over a number of submissions. In other words, there were a lot of different times when things were sent to the lab and you were asked to conduct DNA testing on those items.
That's correct.
So I want to talk to you about some of these items. Did you receive an item identified as a gauze pad or gauze wad there into the lab for DNA testing?
Yes, it did.
All right. May I approach the witness, Your Honor?
May.
Showing you what's been entered into evidence that states that there are 13, 14. Can you take a look at that and tell me if those are the items?
Yes, I recognize the package with my initials on the label and then the FDLE case number. And the gauze are items 211 and 211 and 212. And yes, these are those items.
Okay. And so you received these into the lab and conducted DNA testing on them?
Correct.
Did you also perform a test to determine the possible presence of blood?
Yes, it did.
What were the results of your testing, both of for the presence of blood and your DNA testing?
Both items were positive for the presence of chemical presence of blood. And on 211, which was described as a gauze pad, I obtained a partial DNA profile that matched Michael Elijah Otto.
Okay, and just to kind of back up maybe just for a little bit, previously there had Mr. Gorgon had conducted DNA testing on an item in order to obtain a secondary standard for Michael Otto. Is that correct?
That is correct.
And is that the profile that you used to compare the profile that you found on the gauze pad and the wad?
Yes, it is.
Okay. And you said that the profile you found on the gauze pad and gauze wad was a partial profile?
That is correct.
And that I know that Mr. Gorgon sort of explained sort of what a complete profile is versus a partial profile. And this was something less than the 15 locations that you test for. Is that correct?
That is correct. It was actually at 15 of the areas I was able to compare, but at one of those 15, it was just an incomplete information. And so it's a partial profile at the 15 areas.
Okay, so one of those areas was one allele short.
Correct.
Is that correct? But you were able to compare it and found that it matched Michael Elijah Otto's DNA profile. Is that right?
That is correct.
All right. Now, did you also receive, and we've already heard some testimony concerning swabs from an area called the master bathroom. Did you also receive some additional swabs?
Yes. Can you narrow it down as far as?
Sure. These would be from submission 24 and 25, and they're identified as master bath 8, 10, 11, 12, 15, and 16. And they would be your FDLE 109, 110, 111, 112, 113, and 114.
Do you know what submission?
24 and 25.
Yes, submission 24, swabs in the master bathroom. And submission 25, there was also other swabs in the master bathroom. Yes.
Okay, so you received 6 packages containing swabs from those areas. Is that right?
Correct.
All right. May I approach the witness, Shawn?
You may.
Showing you what's been entered into evidence as Safety Exhibit 25, 27, 28, 29, 32, and 33. Take a look at those and tell me if you recognize those as swabs of reference.
Yes, I do recognize them as, again, with my initial on the seal, FDLE case number, and then the corresponding numbers that match, or matching my report.
I know we've heard testimony simply for the process of items like this, where you test it for the possible presence of blood, and then you conduct DNA analysis. Is that what you did here?
Yes. For, go ahead.
Go ahead.
Or for 229, or my 229, 230, 231, and 232, those failed. They were negative for the chemical indications of blood.
Okay. And just to be clear, what were those numbers again?
It would be my FDLE 229, 230, 231, and 232.
Okay, so that would be master bath number 8, master bath number 9, master bath number 11, and master bath number 12?
It would be master bath 8, 10, 11, and 12.
Okay, and you said that those tested negative for the presence of blood?
Correct.
All right. And what about with regard to master bath number 15, master bath number 16, which would have been your FDLE 113 and FDLE 114?
Well, for my FDLE number is 233.
Okay, I might have gotten the number switched.
Yeah.
So,
So it's FDLE 233, which is swabs from the master bedroom 15. Or, I'm sorry, master bathroom 15. They were positive for the chemical indications of blood.
okay, and master bath 16, which would have been your 234?
They were also positive.
All right. And did you conduct DNA testing on those two items?
I did, yes.
And what were the results of your DNA testing?
For 233, the swabs from master bathroom 15 obtained a partial DNA profile that matched Thalia Otto.
Right. And were you determined that she was the source of that DNA?
Yes.
All right. Now, I know that we had some testimony earlier about statistical calculations that are performed. Did you perform those type of statistical calculations with regard to these items, and has that changed in the course of your work at FDLE, and if so, can you explain that?
Sure. Going back to the previous match, it was prior to April of 2015, where a frequency of the match was reported. And to go back to that match, for the gauze pad,
Yes, sir.
it was that matched Michael Elijah Otto. That was the frequency would be approximately 1 in 260 quintillion, which is 1 with 18 zeros in 1 quintillion. After April of 2015, FDLE decided as a lab system, if the frequency is more rare than 1 in 700 billion, which is approximately 100 times the Earth population, then we would actually say that that individual was the source of that DNA profile. So anything after April of 2015, during this case, if I'm able to say that this for individual matches and is the source, then it means the frequency was more rare than 1 in 700 billion.
And you're saying that within a reasonable degree of scientific certainty, correct?
Correct.
And that threshold number is 1 in 700 billion?
Yes, which is approximately 100 times the Earth population.
A number lower than that would still be significant, would it not?
It would.
And you said in this particular case that those numbers were higher than 1 in 700 billion, correct?
Yes, they were. Yes.
For both master bath 15 and 16?
No, just master bath 15.
Okay. And what were your results as it relates to master bath 16?
Due to the limited nature of the results I obtained from master bath 16, the data was insufficient for inclusion, but I could use it to exclude an individual.
Okay. And with regard to Talia Otto, could you determine whether or not she could be included or excluded?
No, there's no determinations, meaning that she could neither be included or excluded from those DNA results.
Now, you also had profiles on hand to compare profiles from a number of other known sources, correct?
That's correct.
Including Shawn Jackson, is that right?
That is correct, yes.
And the defendant, Luis Toledo, is that correct?
That's correct.
And a number of other family members. Was everyone else excluded?
Yes, every other DNA profile that I obtained from a standard and from the case were excluded as a source.
Okay. Only Talia Otto could neither be excluded or included.
Correct.
Now, I want to ask you some questions about some swabs identified as swabs from Blue Star area. Now, before I get specifically into those questions, Blue Star, you recognize that as a product that's used quite a bit with crime scene investigators. I think some people refer to it as luminol or something of that nature.
I know of it. I'm not familiar. I've never used it.
Okay, all right. And you received a number of swabs identified as from a Blue Star area. Is that correct?
Correct.
All right. And approximately how many swabs did you receive?
What's the submission?
I'm sorry, submissions, there are submissions 25, 26, and 27.
In submission 25, I received 3 swabs from Blue Star area. And submission 26, I received, I believe I have 7.
Okay. So you received 10 swabs from that area?
Correct.
All right, or those areas. What were your results when you performed the test for blood and DNA?
The swabs in Blue Star areas 1, 2, and 3 failed to give chemical indications of blood. Swabs 4, 5, 6, and 7 in submission 26 also failed to give chemical indications of blood. Swab 8 from Blue Star area 8 gave chemical indications of blood. I ran DNA analysis on those swabs, but due to the limited results, or limited nature of those results, they were not interpretable. And then swabs from Blue Star areas 9 and 10, they failed to give chemical indications of the presence of blood.
Okay. Now, can cleaning chemicals have a negative impact on blood stains or your ability to determine the presence of DNA within a stain?
Yes.
I want to go to, you received a number of swabs from a silver Saturn, is that correct?
Correct?
Actually, you received a lot of swabs, didn't you?
Yes.
Okay. And most of those either were negative for blood or there were no DNA results that you could report out, is that correct?
Best of my recollection without specifically going through.
Okay. Specifically, though, with a swab that you received, did you receive one from the gear shift of the silver Saturn, which I believe would be your 220 out of submission 22?
Yes.
Okay. And when you conducted DNA testing on that swab, what were the results that you were able to determine?
There was no testing for blood on the swab. It was not in any color that would be considered possible blood. Performed DNA analysis and obtained a partial DNA profile.
All right. And did you compare that with any of the standards that you had at hand?
Yes, it matched Lewis A. Toledo.
Okay, and were you able to determine that within a reasonable degree of scientific certainty?
Yes, it was.
Did you also receive swabs from an area identified as the right rear armrest of the silver Saturn? I believe that was your 225 out of submission 23.
Yes.
And what were the results of your DNA testing on those swabs?
Obtained a complex mixture, and due to the complexity of the mixture, it was insufficient for inclusion, but I could use it to exclude an individual.
Okay. And were, out of all of the standards that you had on hand, was there anybody that, well, let me just ask, what were your results when you compared it to the standards that you had received?
Due to the complexity of the mixture, Michael Elijah Otto could not be neither included or excluded as a contributor to that mixture.
Okay, and what about all the other standards that you had received?
They were excluded.
So everyone was excluded except for Michael Elijah Otto, who you could neither include or exclude?
Correct.
Now, just very quickly, you also received a number of swabs identified as coming from from a Honda Accord. Is that correct?
Correct, yes.
All right. And just out of all these swabs that you received, is it correct that they either tested negative for blood or there were either no DNA results that you were able to report out?
Again, to the best of my recollection, without specifically going through, yes.
Okay. Going to submission number 30, did you receive an item identified as swabs from a handle of a red cedar mop from garage, which I believe is your 265?
Yes.
Okay. And what did you do with that item?
I tested it for the presence of blood, and it failed to give the chemical indications of blood.
Okay. And there was 3 items I wanted to bring up. Swabs, these are your 266, 267, and 268 out of submission 31, and these are swabs from a handle of a red quickie mop from garage, swabs of a handle of a red Libman broom from kitchen, and swabs of a handle of a yellow broom from laundry closet.
Yes.
You received those?
I did.
And what did you do with those items?
Upon visual examination, there's no stains of significance for any testing.
Okay, and this is just a visual examination that you're performing, and you saw nothing of significance?
That's correct.
All right. And did you also receive swabs from a garage door button, which would have been different from another item that had previously been tested, and swabs of a handle from a spade shovel in the garage, which would have been your 269 and 270 out of submission 31?
I did receive those, yes.
And those were negative for blood as well?
That is correct. Negative for blood.
Now, I think there were some questions asked earlier. There's not really any way to date DNA, is that correct?
No, only that it was deposited before the last time it was wiped off or washed off.
Okay.
Really.
It is sometimes one of the ways that you might be able to do that is if, say, blood was left from a scene and if there's some way to connect that up, you might be able to determine a date for that.
There's no, you'd be able to get results or you would not be able to get results. As far as the timing of everything, it would be, there's no test for that.
Okay. I mean, for example, if a bottle is left in a house and there's no blood on it, that bottle, any DNA on that bottle could have been left there months, weeks, days in advance, correct?
Yes.
The presence of blood from a specific event that may be able to narrow that time frame down, correct?
Yes, but not, the actual DNA testing wouldn't narrow it down. It would just be the circumstances.
Sure, absolutely. So the presence of blood could be significant in that regard, but I know that you're not able to do that.
Correct.
Okay. And is that, you received a number of other items, specifically swabs from a chin-up bar in the master bedroom or bathroom, which is your 271 from submission 31.
Yes.
As well as a mean green spray cleaner bottle, area rug from the living room main entrance, and a metal/foam chin-up bar from the master bathroom. Is that correct?
That's correct.
And this, you saw no stains of significance on those items, correct?
That is correct.
Again, you're looking for blood or some type of stain in order to determine if further DNA testing is needed.
Correct.
Right. And if you don't see blood, you don't go forward and conduct any further DNA testing for that reason.
In this case, that's correct.
You also received swabs from a Zephyr Hills bottle, which is your 277 from submission 33. Is that right?
Yes.
And on that, you saw no stains of significance. Is that correct?
That's correct.
And then swabs from an Athletic Planet bottle, which is your 278 out of submission 33. Is that right?
That's correct.
And that tested negative for blood.
That was negative for blood. Yes, correct.
Out of all the items that you tested, sir, Did any of the items that was submitted and that you conducted testing on contain a DNA profile that either matched or even potentially included Tyshawn Jackson?
No.
May I have a moment, Your Honor?
Yes, sir.
No further questions.
Any cross-examination?
Thank you, Your Honor. Good afternoon.
Good afternoon.
Analyst Johnson, I just asked this question of Analyst Gargone before. When you say due to the limited nature of the DNA results, the data is not interpretable, that means that you have some DNA, but it's of such small amount you can't interpret it one way or the other.
That's correct.
And when you say there's no stains of significance, that means that there's no stains that could be tested for blood.
Correct.
You tested a silver Saturn, and especially the floor mats for the silver Saturn. That would be exhibits 254, 255, 256, and 257.
Do you recall what submissions they were?
I knew you were going to ask me. Submission 19.
$254, $255, and $256?
And 257.
Yes.
Okay, submission 19. There was no indication of blood on any of those items.
That is correct.
And those would be the right rear floor mat, the right front floor mat, the left front floor mat, and the left rear floor mat of a silver Saturn.
Correct.
Also, you tested a center console dashboard in the center console, in the silver Saturn.
Do you have the number?
Exhibit 2, we have exhibit numbers and FDLE numbers. I was going to say exhibit 249.
Yes, I did.
That would be exhibit 28, submission 28 for you.
Yes.
Right, and that did not come back with any indication of blood.
Correct.
And also in that submission, there was a swab from a glove box where there was a black cloth in it. And that did not come back with any indication of blood, correct?
Correct.
And there was also swabs from a green blanket that didn't come back with any indication of blood.
Correct.
Now, you also had about 16 other swabs from anywhere inside this Saturn, where you're looking for blood and DNA, but none of them came back as indication of blood, correct?
Which
I'm just talking in summary of your Saturn examination.
It'd be hard for me to speculate without the exact. I mean, I would be speculating until I narrow it down specifically.
Let me try to help you do
Okay.
something. Submission 21,
Okay.
which would be swabs from the left half of the steering wheel, no blood.
Actually, they were just, there was no testing on those for blood. They were just, I performed DNA analysis on those.
Okay, so there was, and the DNA was not interpretable on that.
That's correct.
So I want to talk about all your submissions in submission 21. Did any of those in submission 21 come back as positive for blood?
They were not tested for blood.
They were not tested for blood.
Correct.
Why was that?
Because they weren't red-brown color, or the swab coloring didn't give me any reason to think it may be blood.
So there was either no stains of significance that you visually saw, or you were just searching for DNA.
Correct.
Now, you went through 6 swabs from the master bathroom. In this submission 24, 20, and 25.
Okay.
And in submission 24, master bath 08, master bath 10, master bath 11, and master bath 12 failed to give indications of blood.
Correct.
Master bath 15, you found a partial DNA profile for Talia Otto.
Correct.
And master bath 16, you found some DNA, tested positive for blood, but it was of such limited nature, the data was not interpretable.
It was suitable for exclusion.
Okay, that's master bath 16.
Correct.
And you wrote, actually, in that one, that due to the limited nature of the results, value auto can neither be excluded or included as a contributor.
Correct.
And with regard to the Blue Star, you had 10 separate swabbings from 10 separate areas. Is that correct?
That's correct.
And only one came back as positive for blood. And that would be Blue Star area 08.
That is correct.
And however, when you went for DNA testing on that, it was due to the limited nature of the DNA, the data is not interpretable.
That's correct. Yeah.
So that means we have some DNA there, but it's of such little amount you can't go any further.
Correct.
You took some swabs from Honda Accord.
Yes,
This
I
would be
received.
submission 27.
Yes.
And this would be exhibit 245A, which was swabs from around the inside and inside the latch of the trunk area.
Correct.
And that failed to give any chemical indication for blood.
Correct.
And also 245B, which was a ridge area of the rubber gasket around the trunk, failed to give any indication for blood.
I did not test that for blood,
Okay.
but ran DNA analysis on it.
Okay. And did you get any DNA on that?
No, well, I did, but it was limited and not interpretable.
So there was some there, but it's so small we can't interpret it.
Correct.
And exhibit 246, these are also swabs from the trunk area of the Honda Accord. 246A was a swab under the latch area, failed to
Yes.
give an indication for blood.
It was not tested for blood.
It was not tested for blood.
No,
246A
246A.
was not, but 246B was.
Yes, and it failed to give indication for blood.
Now, I know you touched on this earlier, that there were several items, or swabs from items that were from the garage that you tested.
Yes.
And that would be exhibits 259 through 270. And submission 29?
Yes, submission, yeah, 259 and 260 are from submission 29, yes.
Okay. So 259 was a sponge mop from the garage, and the swab had no indication for blood.
Correct?
And 260 was a string mop from the garage, also no indication for blood.
That is correct.
265, we touched on that. That was the swab from the red cedar mop, no indication for blood.
Correct?
266 swab from the handle of a red quickie mop, and there was no stains of significance there to test.
Correct.
269 swabs from a garage door button, we touched on that, no blood.
On 269, yes, failed to give chemical indications of blood.
And we touched on 270 swab from a handle of a spade shovel from the garage, no
Same,
blood.
same thing, yes.
And you also exhibit 272, which was a mean green spray cleaner bottle in submission 32.
Yes,
You said no stains of significance was found on that.
correct.
So you did a visual examination of that item, and you didn't find any stains to test.
No stain worthy of testing for blood.
And you didn't do any testing for DNA.
No.
Judge, may I have a moment?
Yes, sir.
Mr. Johnson, just a couple follow-up questions. You started talking about a gauze pad and a gauze wad that you received in this case,
Yes,
which came back as DNA to Michael Otto.
correct.
Are you aware that other investigators have testified that this has no significance in this case?
I'm not aware of that, no.
Did you know anything about these items before they came into your lab?
Not specifically, no.
So no facts about the surroundings or evidentiary value?
No, nothing specific, no.
Thank you.
Thank you. Any redirect? All right, may the witness be excused? Yes. The king may step down. State, call your next witness.
Calls Nicole Daniels.
Yes, ma'am.
You can have a seat. Make sure you speak close into the microphone so the jurors can hear what you have to say. You may proceed.
Yes, sir, thank you. Good afternoon, ma'am.
Good afternoon.
Could you tell us your name, please?
Nicole Daniels.
How are you currently employed, Ms. Daniels?
I'm a crime scene analyst with the Seminole County Sheriff's Office.
And how long have you been so employed?
16 years.
Were you working as a crime scene analyst with the Seminole County Sheriff's Office in October of 2013?
Yes, I was.
More specifically, were you acting in that capacity on October 24th and required or called upon to help in an investigation from Volusia County?
Yes, I was.
Okay. Could you tell us how it is that you were involved in that investigation and what you did explicitly?
Yes, I was contacted by the Seminole County Sheriff's Office dispatch and requested to respond to the Sheriff's Office to assist in processing a vehicle.
And approximately what time were you called to assist in processing this vehicle?
Approximately 3:25 a.m.
Did you gain any assistance from authorities from Volusia County during your processing of the vehicle?
Another crime scene analyst with Volusia County was present, yes.
And that would that be an individual by the name of Eugene Mefford?
Yes.
Had you met Investigator Mefford before this date?
Not that I remember.
As it relates to your processing of this particular vehicle, was there anything specific that you were looking for?
We were looking for possible blood. We were looking for possible fingerprints, any sorts of hairs or fibers, just various types of evidence.
Essentially any evidence that you could find?
Yes, sir.
How many times did you actually process this vehicle in this case?
I entered the vehicle on 3 separate occasions.
Why more than just the one time?
Questions came up at later dates, and we were requested to look for additional information.
Now, as far as the vehicle registration and the plate for this particular vehicle, is that something that you would look at or consider during the course of your processing?
Yes, we generally will document the plate and the VIN of the vehicle as we are taking notes and photographs around it.
Were you aware that the plate and VIN came back to an individual by the name of?
I don't think he finished the question, but I'll sustain to rephrase it.
That's fine. Did you do anything to conduct a search for the registered owner of that particular vehicle?
I did not, no.
Do you know if anyone in Volusia County Sheriff's Office did?
I'm not aware of what they did.
Okay. During your interior and exterior search of the vehicle, did you find any personal belongings that may be related to the owner of the vehicle? Owner or occupants of the vehicle?
No, I'll overrule it. Go ahead.
Thank you, Your Honor. Did you find any personal belongings within the vehicle, ma'am?
Yes, I did.
What did you find exactly?
I located a purse with some ID. I located a cell phone wallet that had an ID contained in it. And I located some additional items that had names on it. There was a folder, I believe, that had a name on it and a tablet with a name on it.
Is the name Yesenia Suarez familiar to you?
Yes, sir.
And did you find that name on more than one of the items contained within the vehicle?
Yes, sir.
Ma'am, again, did you find the name of Yesenia Suarez reappearing throughout the vehicle on different IDs and different items that were personal in nature?
Yes, I did.
Did you take any photographs during the course of your investigation as it related to this vehicle?
Yes, I did.
Your Honor, may I approach the
You may do so.
approaching the question Mark states 5 V's, 1 and 2 for identification purposes. Do you recognize that exhibit?
Yes, I do.
And what do you recognize it to be?
I recognize it to be several photos of the vehicle that I processed.
Okay. Have you had an opportunity to review those photographs prior to your testimony here today?
Yes, I have.
And you signed and dated this both on the digital form as well as the printed paper copy of the document?
Yes, I did.
Judge, if there are no objections to this point, or subject to objections being raised on the they would move 5 V's, 1 and 2.
Okay, they will be admitted into evidence.
look at the screens here with me, I'm going to show you Exhibit A on States 105A. Do you recognize this vehicle?
Yes, I do.
And how do you recognize the vehicle?
That is the vehicle that I processed.
Okay. The black Honda Accord that we've been speaking about the last few minutes?
Yes, sir.
Okay. What is the setting of this photograph?
This is the Seminole County Sheriff's Office. This is one of our garage bays, and the garage bay door is open.
I'm going to show you, before I show you photograph B, can you tell me whether there were any markings that you took note of on the outside, the exterior of the vehicle? Well, let me show you photograph B and see if you can tell us what we see in this photograph.
The evidence seal near the bottom of the door.
Okay. Did you notice any signs of a cleaning or
Overall,
did you notice any signs of any sort of cleaning or spray on the exterior of the vehicle that were inconsistent with the balance of the vehicle?
I did notice that there were some marks, or what appeared to be drip marks, on some areas of the vehicle.
And which areas in particular of the vehicle, if you recall?
The trunk, and on the driver's side, there were some, what appeared to be some drip marks near the windows.
Okay. Is that what we see in addition to the evidence tag on photograph B?
Yes.
Do we see more of the same on photograph C?
Yes.
As well as photograph D? Do you see more of the same kinds of drip marks around the doors?
Yes.
And finally, again, on photograph E, do you see the same drip marks on the trunk area?
Yes.
As it relates to the interior portion of the vehicle, I believe you already testified that you found an ID associated with the phone wallet. Is this the idea that you've discussed?
Yes, that's correct.
Photograph G is a closer picture of that photograph, or of that identification?
Yes.
As it relates to fingerprints or DNA analysis within or DNA collection within the vehicle, did you or investigator Mefford attempt to obtain samples for DNA analysis or latent prints that were lifted and retained for analysis by the sheriff's office?
Yes, to both.
And do you recall how many of each?
I recall that there were 6 latent lifts that were collected. If I may refresh my memory
Sure.
through my notes, I could tell you.
Absolutely.
Okay. And 12 swabs.
Now, you had nothing to do with the actual analysis of these items, just collected them and sent them on for further processing. Is that correct?
I collected them and turned them over to crime scene analyst Mefford for them to send on for further analysis, yes.
Okay, thank you, ma'am. As it relates to the vehicle and the electronics within the vehicle, did this particular vehicle come equipped with any sort of GPS location device or any sort of tracking?
It appeared that there was a GPS monitor within the vehicle.
Okay.
Yes.
And that GPS monitor didn't include any sort of trip history or history at all, did it?
No, it did not.
Okay. As far as the recorded mileage or the gasoline consumption or the statistical information related to the onboard computer, again, nothing significant in this case, correct?
I recorded a mileage and I recorded a level of gasoline, but that's the only information I was able to collect from that.
Within the vehicle, did you find anything on the on the driver floorboard behind the driver's seat?
I located a floor mat that had a possible footwear impression.
I'll show you what's been marked as photo H from your photographs. Is this the photograph that depicts that footwear impression, ma'am?
Yes, it is.
And do you recognize taped evidence number 84 without opening it?
Yes, I do.
Is that the footwear, or excuse me, is that the floor mat pulled from the Honda Accord interior that we see in the photograph?
Yes, it is.
Okay, and to your knowledge, does it still have the sandy footprint on that mat?
To my knowledge, yes.
Did you and Investigator Mefford take special steps in trying to keep that footprint intact?
Yes, we packaged it in a way to attempt to preserve it as best we could and photographed it in addition to the photograph in the vehicle to preserve the evidence in the best manner we could.
Okay, thank you, ma'am. Could you tell us what we see here in photograph I? What is this?
This is the passenger seat, the open glove box. There's a purse on top of the passenger seat and numerous items within that compartment.
And was the purse and the personal items within the photograph here, were all those retained and eventually given over to the Volusia County Sheriff's Office for further processing?
Yes.
And as it relates to photograph J, what are we looking at, ma'am?
The interior of the trunk.
And was this the way that the trunk appeared to you on October 24th in the early morning hours around 3 a.m. when you processed the vehicle?
Yes.
Was there any trunk liner, any rubber trunk liner in that trunk?
No.
I have no further questions.
Okay, thank you.
Thank you.
Any cross-examination?
Good afternoon.
Good afternoon.
Jeffrey Dean, do you remember a long time ago I took your deposition in my office?
I do.
Okay. I just want to make sure I cover everything that you did with this car. Okay?
Okay.
So, use the forensic light on it,
Yes, we did.
and you collected swabs from various areas of the car. Is that correct?
That's correct.
You vacuumed the interior. Is that correct?
Yes, we did.
You documented all those items that this isn't the only picture of the car there is, right? You went around and took, I want to say, quadrant pictures where you started on the driver's side and then went back to the back seat and then to the trunk and then to the back seat and then up. Is that what you did?
Yes, I took numerous photos.
Okay. You collected that floor mat. Is that
Yes,
correct?
that's correct.
Now, in that picture, you document, well, it's your job to document everything in the car, right?
Yes, it's part of my job to document what I see.
So you try to do inventory basically, but not really, but just to make sure you're covering everything?
Yes, that's correct.
So in that picture, please feel free to refer to your notes. The umbrella in the door, that's not documented in your report, is it?
No, it's not.
The object hanging from the rearview mirror, can you see that in the picture? I think it's just the bottom part. Can you see it? It's kind of hard to see on that picture, but.
Not really.
Okay.
Not very well.
Well, let me ask you just a better question. Did you document anything hanging from the rearview mirror?
No, sir.
Okay. And then the blue plastic that's there, did you document that?
Yes, sir.
Okay. So the blue plastic are the flip-flops documented?
Yes, sir.
They're documented as well?
Yes, sir.
With the water bottle, right?
Yes, sir.
When you looked at the entire car and you put everything in the report that you actually did yourself, is that right?
Yes.
Now, this car had been to Volusia County before you saw it, is that correct?
Yes, that's my understanding.
So when you got it, it had already been opened, is that right?
I don't know.
You don't know that?
I don't know.
So the way things are placed in the car or anything like that, you don't know if that's how they originally were or if that's just how you found them when you got there, isn't that right?
Right. I document them as I see when I receive it. So this is how I saw it.
I just need a moment, Your Honor.
Yes, sir. Any redirect?
Ma'am, when you received the vehicle in Seminole County, all the seals were intact on the outer doors, right?
Yes, sir.
Okay, so that's proof to you that no one had opened the vehicle, right?
That's correct.
No matter whether it went to Volusia or not, no one had been in that vehicle.
To my knowledge, no one had been in that vehicle.
And that's why law enforcement puts seals on the vehicles, is so that you're comfortable in knowing who's been there before you. Isn't that right?
Correct.
Now, I noticed that we talked about an umbrella and something hanging from a rearview mirror that weren't in your report, but you took photographs of them, right?
Yes, I did.
In fact, you took photographs of everything that you located in that vehicle, didn't you?
To the best of my ability, I did, yes.
Okay, thank you, ma'am. I appreciate it.
Okay.
Do you know how the car looked before the seals went on?
No, sir.
Thank you.
I think any redirect? All right, may the witness be excused? State?
Yes, sir.
Defense? Okay, then you still need to maintain contact with the state or somebody, okay? Or you can leave for today.
Thank you, sir.
All right, thank you. We're going to take a break. Take a 15-minute recess. I'll come back at about 5 to 3. Take them over there, yes, Mr. Stretch.
All rise. Education training as it relates to that field.
I have a bachelor's degree in criminology. With the Florida Department of Law Enforcement, I completed a two-phase training program. The first phase being your academics, articles, book reading, testing, and the second phase being a period of supervised casework, where I would work a case completely through on my own, and then another analyst would rework the case to make sure I use the proper notes, skills, and abilities.
How many analysts work in the footwear impression section there in Tampa?
5.
And are y'all the only section in the state of Florida?
Yes.
And how many of them are senior analysts such as yourself?
3.
Now, who did you work for prior to working with FDLE? What kind of work did you do prior to that?
I was a crime scene technician with the Manatee County Sheriff's Office for 3 years and was hired with the Florida Department of Law Enforcement in the crime scene capacity. And then I cross-trained into impression evidence.
Okay, and how long have you been working in impression? And you may have already answered this question, but just to be clear for the record, how many years have you been working in the impression evidence section?
15.
Are you a member of any professional organizations in this field?
Yes.
And what organizations are you a member of?
The International Association for Identification, the Florida Division of the International Association for Identification, and SWIGTRED.
And what does that stand for?
Scientific Working Group for Impression Evidence.
Okay. Are you certified by any of those organizations?
Yes.
And which organizations?
The International Association for Identification offers a certification in footwear.
And what do you have to do to become certified by that organization?
You have to have at least 3 years of working experience on the bench being an analyst. You have to take a written test and then also a comparison test.
How many other impression evidence analysts at FDLE are certified by that organization?
None.
You're the only one?
Correct.
And are you aware of how many other individuals are certified by that organization, such as yourself, total?
Approximately 120 people are certified worldwide.
How often do you have to renew that certification?
Every 5 years.
And what do you have to do to renew it?
You have to take another comparison test and also prove that you've stayed proficient with your education and comparisons.
Have you ever taught or given lectures on any topics related to the field of impression evidence?
Yes, I have.
And can you just maybe briefly describe some of those lectures or training that you've done?
I've done various lectures at law enforcement agencies, but I also lectured at the International Conference in San Diego in the area of footwear impressions and crime scene.
Have you ever been published in the field?
Yes, I have.
And what was the name of the article that you published?
The Rusting of Gelatin Lifters, which was published in the Journal of Forensic Identification.
All right. Now, I know that you may not be able to give an exact number, but can you approximate how many times you've examined footwear impressions in your career?
Tens of thousands of times.
Okay. And do you undergo proficiency training at FDLE?
Yes, I do.
And can you explain exactly what that means? Proficiency training?
Proficiency testing is an outside company provides us a test with known answers. We take that annually.
Okay, and I think I said training, but I should have said testing.
It's
correct?
testing, yes.
It's a little bit different, right? And how many times again did you say that you undergo this testing?
Once a year.
And have you always passed your proficiency testing?
Yes, I have.
Right. Have you ever testified as an expert in the field of impression evidence?
Yes, I have.
And approximately how many times?
Approximately 50 times throughout various counties in the state of Florida.
Now, when we talk about footwear impression evidence, specifically the term footwear, can you tell us exactly what is meant in your field by the term footwear? It may seem obvious to some people, but you maybe have a little bit of a specific connotation in your field. What exactly do you mean by footwear, is meant by footwear in the field?
I'm talking about any type of sandal, boot, sneaker, or shoe.
Okay. And what is a footwear impression?
It is a reproduction of the bottom of the shoe when it comes in contact with the surface.
And how are footwear impressions left?
When the bottom of the shoe comes in contact with the surface, it can transfer residue like dust, ink, or blood to that surface, and it'll leave a reproduction of those features that made contact.
And so they can be left in a variety of ways,
yes.
Correct? Okay. What are class characteristics? What are individual characteristics? Can you explain those terms?
Class characteristics are those characteristics that are made by the manufacturer, like the design, the physical size, the shape, and those characteristics will be repeated in more than one shoe during the manufacturing process. Individual characteristics are also referred to as randomly acquired characteristics, are those that are acquired through use and wear, like nicks on the bottom of your shoe or piece of glass or something that may cut the bottom of the shoe. That'll make that bottom of the shoe unique and more identifiable.
And how are footwear impressions compared?
By noting the class and individual characteristics, noting how they're positioned on the shoe and the known impression, and comparing those results to each other.
Now, I want to ask you some case-specific questions. Were you asked to examine some footwear impressions and compare them to specific footwear in this case?
Yes, I was.
All right. And were there photographs that you have reviewed in relation to your work and that you've reviewed prior to your testimony today?
Yes.
May I approach the witness, Shawn?
You may.
Yes, I do.
Okay. And those are the CD that contains photographs that we discussed?
Correct.
And 5W2 is simply a printout of the same photographs, is that correct?
Correct.
And are they a fair and accurate representation of your work in this particular case?
Yes, they are.
Can I have a counsel sidebar? I'm sorry, the item will be received in evidence. Go ahead. Mark it.
Thank you. Now, before we get into the photographs themselves, can you tell us what did you receive, and starting with your submission number 30 from your July 24, 2015 report, can you tell us what exactly did you receive in your lab?
I received a left black Timberland boot, a right black Timberland boot with a piece of metal that was in the insole, and a piece of plastic sheeting.
Okay. Did you also receive a CD containing photographs of the boots and footwear impressions?
Not in that submission, no.
Okay. And in the next submission you received, submission number 40 from your February 1st, 2016 report.
Yes, I received the same pair of shoes or boots back in. I also received a black vehicle floor mat and a CD containing 39 images.
Now, specifically with regard to the boots, you actually received the boots themselves, correct?
Correct.
And did you have a chance to examine the boots?
Yes, I did.
And do you recall what size the boots were that you received?
7M.
All right, I'm showing you here from Exhibit 106A, Photo A from that exhibit. Are these the boots that you received into the lab, and is this a photograph that you took?
Yes, it is.
All right, showing both of the right and left boots?
Correct.
All right. And photograph B here, what are we looking at there?
It's the outsoles or the bottoms of the boots.
May I approach the witness?
May.
Showing you what's been entered into evidence that takes you to 80 and 81. Can you take a look at those and tell me if you recognize those?
Yes, I do.
And are those the boots that you received?
Yes, they are.
Now, when you received the boots, what did anything stood out to you about them?
I made note that on the right outsole and also on the right upper, there was a white powdery substance.
Okay. Now, you also received, as a part of your submission number 30, and you may have mentioned this, a plastic sheeting, is that correct?
Yes.
may.
Showing you what you entered into evidence as stated Exhibit 78. Look at that, tell me if you recognize that as the plastic sheeting you see.
Yes, it is.
And how do you recognize it to be that?
It has our yellow unique FDLE lab sticker. It also has the case number, my initials, and the exhibit number in my handwriting.
Now, when you received the plastic sheeting, did you remove it from the packaging and make a visual inspection of it?
Yes, I did.
And what did you notice when you physically or visually examined the plastic sheeting?
That there were approximately 3 footwear impressions and some impressions of unknown origin on it in a white powdery substance.
And how many did you see?
There were 3 footwear impressions and impressions of unknown origin.
Okay. I'm showing you photo C from Exhibit 106A. And is this a photograph of the plastic sheeting?
Yes, it is.
All right. You said there were 3, you observed 3 footwear impressions on the sheeting?
That's correct.
I'm showing you photo D. Are these photographs of the footwear impressions that you observed?
Yes, they are. Those are my photographs.
Okay. And of course, the color looks a little bit different. Can you kind of explain how you took these photographs and why they look the way they do and why they might be a little bit different than what we looked at in the previous photo?
It is a clear sheeting. It is on a dark background to give me contrast so I can visualize the details that are in the impressions.
Okay. And of course, there's 2 separate photographs here, correct?
Yes.
And you said that you visually observed 3 footwear impressions. Can you tell us where the 3 footwear impressions are on these 2 photographs?
In the photograph on the left, it is next to the ruler. And in the photograph on the right, there is a heel towards the left side of the photograph, and then towards the right corner, there is another partial impression.
Okay. So the left photograph has 1 footwear impression, and then the right photograph has 2 footwear impressions. Is that correct?
Correct.
And those are partial impressions?
Yes.
Now, I think you had already mentioned one of the things you noticed specifically about particularly the photograph on the right-hand side was one of those contained a heel impression. Is that correct?
Correct.
Now, can you describe the process that you go through when you're going to compare a footwear impression from an unknown source to a particular piece of footwear? Can you kind of describe the process that you go through to make that comparison and potential identification?
The first thing I would always do is to inventory the contents as I received them and photograph them, as you see, in the condition that I received them in. This is the condition that I received the sheeting in, and then also the uppers and the outsoles on the previous images is how the condition was when I received them. After I'll note their condition and photograph them, I'll then process. In this particular case, I used gelatin lifters on the plastic sheeting, and on the boots, I made what's called an overlay, which is by placing a thin layer of black ink on the bottom of the shoe, and then pressing it against a clear acetate. It'll give me a reproduction of all the features that are on the bottom of that shoe.
Now, you mentioned that you do an ink overlay on the actual items of footwear. Is that correct?
Correct.
All right. And photograph E on Exhibit 106A, are these photographs of inked overlays that you made of the boots in question?
Yes, they are.
May I approach the witness again?
You may.
Showing you with the mark for identification purposes as State's Exhibit 5X's1, 5X's2. You can take a look at that and tell me if you recognize it.
Yes, I do.
And what do you recognize them to be?
These are the overlays that I created using the boots.
These are the actual overlays you did, not just the photographs, correct?
Correct.
Now, at this time, I'd offer that you give us 5 Texas 5 Texas 2.
Okay. The items will be admitted into evidence.
Now, you indicated that with regard to the, going back to photo D here, with regard to the footwear impressions that you observed, the 3 of them that you observed on the plastic sheeting, you indicated that one of the things that you did in order to process that further was you conducted a gelatin lift. Was that correct?
That's correct.
And did you photograph those? I know here we're looking at, you said it's basically a basic photograph with the translucent sheeting over a dark background. Did you also do sort of an inverted photograph? In other words, almost like a negative image.
Correct.
And why would you do that?
It gives better contrast and it's easier to visualize.
May I approach the witness, Your Honor?
You may.
I'm showing you what's been marked for identification purposes as State's Exhibit Y, 5 Ys and 5 Zs. Can you take a look at those and tell me if you recognize those as the inverted photograph of these 3 shoe impressions?
Yes, they are. These are the inverted colors of the gelatin lifts that I made.
Okay, now these are large photographs. Is there anything significant about its size?
They are to scale.
So these would be the actual, how these shoes, the actual size that we would actually appear.
Correct.
Your Honor, offer State Exhibit 5 Ys, 5 Zs in the evidence.
The items will be admitted into evidence. Objections overruled.
Now, after you do the ink overlay of the actual boots that are in evidence, and you did the gelatin lift of the actual impressions from the plastic sheeting, what did you do next?
I attempted to develop any latent footwear impressions by using a process called superglue fuming. Any superglue fumes would adhere to any moisture that might be found in a print, and it would make it visualized.
Okay. And of the 2 processes that you used, the gelatin lift and the superglue fuming of the plastic sheeting, which one did you find to be more helpful in your analysis?
The gelatin lifts.
Okay. And after you got done with that process, you have the gelatin lifts and you have the inked overlays. What did you do?
I did my comparison and used the actual boots with my overlays and the photographs and the gelatin lifts, and I arrived at my conclusions.
Okay. And what are you looking for when you, or let me back up one question. Exactly how are you doing that? How are you making that comparison?
I'm using the overlays and superimposing them over the actual impressions.
Okay. And as you do that, what are you looking for?
I'm looking for any agreement or disagreement of class characteristics. If there's disagreement of class characteristics, then I can stop my comparisons. If there's agreement of class characteristics, I'll then move on to try and locate any individual or randomly acquired characteristics.
With regard to, I'm going to take you to photo G on this exhibit, which is 106A. And again, in this particular photograph, you had indicated that you observed 2 footwear impressions. Is that correct?
That's correct.
And after you went through the process of using the inked overlay and superimposed it over the gelatin lift of that footwear impression, what conclusions were you able to make in your expert opinion?
That one footwear impression could have been made by the right heel in the boots that I received, and the other shared similar characteristics with both of the boots that I received.
Now, the one there on the left-hand side of the photograph, what again was your conclusion?
That it could have been made by the right boot that I received.
Okay, and what similarities did you observe in that impression and the inked overlays from the actual boots?
There's similar design, which are the lugged pattern and the Swiss cross stars in the middle. There's physical size, which is the actual physical size of the elements and their spatial relationship to one another, and also shape, because I can determine left from right.
Okay, and you're saying that that footwear impression, in your expert opinion, could have been made by the boots that were in evidence?
By the right boot, correct.
The right boot.
Yes.
With regard to the footwear impression on the upper right-hand side of the photograph, what was your conclusion?
That there were similar design features that could have been, or were consistent with either boot.
Okay. Now, is there sort of a hierarchy of when you're drawing conclusions and making these comparisons, is there sort of a hierarchy from, it's definitely not the shoe to, yes, it absolutely is the shoe? Is there a hierarchy in terms of your conclusions?
Yes.
And what is that hierarchy?
We have a range of conclusions. Starting at the bottom, it would be an elimination, which means the impression has different class characteristics than the known shoe, which means it could not have been made by that shoe. Then there's dissimilarities, but the features aren't clear enough to permit an exclusion. And there's a limited association of class characteristics. And there would be a could have or an association of class characteristics, which means all the class characteristics are present. And above that would be most likely made by, which is there's agreement of all class characteristics, plus maybe an individual that doesn't reproduce or there's not enough clarity to affect an identification. And then at the top would be an identification, which means there's an agreement of all of the individual and class characteristics.
Okay, and just to be clear, you're not making an identification in this particular case, is that correct?
That's correct.
All right. And let's start with the footwear impression there. That's identified as the bottom, which is on the the left-hand side of the photograph. Where amongst that range of conclusions that you had just sort of outlined, where would that footwear impression fall in comparison to the boots that you examined?
It would be in the middle, would be a could have been made by, which is an agreement of class characteristics.
Okay. And just to kind of talk about that for a little bit further, the conclusions that you're making when you say it could have, you're actually finding similarities in all of the class characteristics. Is that correct?
Correct.
And that is design, physical size, and shape.
Correct.
You simply do not have any individual characteristics in order to go further with your conclusion. Is that correct?
Correct.
Okay. And with regard to the shoe impression on the right-hand side, where does that fall in your range of conclusions?
That would be right underneath, which would be a limited association of class characteristics, which means some characteristics are present, but not all.
Okay. Now, you had indicated that when you're talking about class characteristics, you're looking at design, physical size, and shape. How many of those three elements that you generally would look for in class characteristics did you find in the footwear impression there on the right-hand side?
2.
So 2 of the 3.
Yes.
And I want to take you to photo H here, and this was the other footwear impression that you noted on the black plastic sheeting. What conclusions did you reach when you went through the process of using your inked overlay on the gelatin lift and making your comparison?
That it shares similar design features with both of the boots.
Okay. And of the three class characteristic elements, size, design, and shape, how many of those did you find in this particular footwear impression?
2.
Now, when you received your other submission, which was submission number 40, you also received an additional item of evidence to compare to the boots as well. Is that correct?
Yes, it is.
And I believe you indicated that was a black vehicle floor mat with a footwear impression.
Correct.
And you also received a CD with photos of that, correct?
Correct.
Which of those did you find more helpful in making whatever conclusions you could make in this case?
The CD.
All right, I'm showing you photograph I. Is that a photograph of the shoe impression on the floor mat?
Yes, it is.
All right. And when you, tell me the process that you went through in order to do a comparison of this footwear impression with the boots in question.
I first looked at the image and determined if there was anything suitable for me to compare. I noted that there were at least two footwear impressions that were suitable for comparison, then compared the class and or individual characteristics that were present in the impression and the known shoe.
Okay. Did you, did you take any additional photographs of this?
I did.
Okay. And did you make a printout of that photograph to scale?
Yes, I did.
First witness, Your Honor.
You may.
And the ruler in the photograph helps you be able to do that. Is that correct?
Yes, having the ruler in the photograph allows me to enlarge the image to its natural size.
Showing you what's been marked for identification purposes as 6A's. Can you take a look at that and tell me if you recognize it?
Yes, I do.
And is that the photograph that you were just referring to of the shoe impression on the format?
Yes, this is one of the images that was on the CD that I received.
And this is the scale?
Yes, it is.
This time I overstate
The item will be admitted. Objection is overruled.
Now, did you also, in making your comparisons between this footwear impression and the boots in question, did you also use the inked overlays that we've talked about already?
Yes, I did.
And after you conducted that comparison, what were your conclusions?
That there were two footwear impressions. One right footwear impression could have been made by the right boot, and the other shared similar design features with both boots.
Okay. And you said there were two here, and one appears to be fairly obvious. Can you kind of point out where the second footwear impression is in this photograph?
There's the beginning of a heel impression in the center area of the darker footwear impression, and then there's a lighter toe to the top right of the image.
Okay. And with regard to these footwear impressions, these two footwear impressions, what were your conclusions?
That one footwear impression could have been made by the right shoe, and the other shared similar design features with both boots.
And the one you said could have been made by the boots in question, this is the one that's sort of oriented vertically, is that correct?
Correct.
All right. And you said that that corresponded in design, physical size, and shape with the right Timberland boot?
Correct.
And can you tell us kind of where that falls in that range of conclusions that you had kind of laid out for us earlier?
It's in the middle where it could have been made by that boot.
And then the other partial footwear impression that you indicated that you observed from this photograph, what were your conclusions?
That it shared similar design features with both of the boots.
Okay. And this is the one you kind of indicated was sort of at an angle in comparison to the other footwear impressions. Is that correct?
Correct.
Yes, sir. May proceed.
Your Honor, may I have the witness stand down and sort of
Yeah.
demonstrate sort of how she makes these comparisons?
And counsel, feel free to move on.
Ms. McConaughey, I want to show you State's Exhibit 109. This was an inverted photograph of the gelatin lift from the two footwear impressions that you observed on the plastic sheeting that were close together. Is that correct? Okay. You'll take that right there. And then these two items, 107A and B, you had indicated that these were the actual ink overlays that you took from the book. Is that correct? Correct. And you basically, can you just tell us, I'm not sure we kind of went through this before, can you kind of give us an idea, how do you do these ink overlays? Okay. And then I guess you just have another piece that you put over it so that it's not sticky when you hold it?
Correct.
Okay. Sort of like a fingerprint.
Correct.
Okay. Could you take these right here and kind of just demonstrate to the jury sort of how you take the ink overlay and superimpose it and then make your comparison? Yes, ma'am. Talk about those eyes. Now, with regard to State's Exhibit 108, can you do the same thing? I'm not sure which of these you need, but. And I want to take State's Exhibit 110, which is a scaled photograph of the footwear impression on the floor mat. And can you demonstrate how you did your comparisons? I have no further questions, Your Honor.
All right, any cross-examination?
Good afternoon.
Good afternoon.
And I'm going to be asking you, Agent McConaughey, to refer to your report.
Okay.
And the first one is going to be the July 24th, 2015 report. 2015 report. Now, before we get to that report, when you received these two Timberland boots, you did a visual inspection of them, correct?
Correct.
And for Exhibit 34, which is a left Timberland boot, it was dry, it was not covered in a white powdery substance, but there was grass and debris in the threads of it, correct?
Correct.
Exhibit 35, which is the right Timberland boot, there was a piece of metal under the insole of the boot.
Yes, I believe it was part of the midsole, but it was loose, so I counted it as something that was there.
And that was in the interior of the boot.
Correct.
And this boot was covered in a white powdery substance.
Correct.
Right? You did not test a white powdery substance yourself, did you?
No.
And did you send it out to get tested or anything?
No.
So besides those, what we just talked about, was there anything else that stood out on these boots at all?
No.
Now, you mentioned class characteristics and individual characteristics. I take it, since nothing stood out on these, there were no readily identifiable individual characteristics of either boot, that is, on the sole.
There may be on the actual boots themselves, but they were not reproduced or in the actual impressions.
So when you roll them and did the impressions, whatever individual characteristic may have been there did not show up on your overlays.
Correct.
Now, with regard to class characteristics, that's pretty general, isn't it?
Yes.
Class characteristics would be whatever came from the manufacturer.
Correct.
So if the manufacturer of Timberland boots makes their soles a certain way, that would be a class characteristic.
Correct.
And if the manufacturer of Timberland boots also makes another boot, maybe Red Wing boot, the same way, they would have the same general class characteristics.
If it's of the same design?
Same design, or a similar design, or same design?
Yes.
So it really depends. When class characteristics, you could be talking about different styles and different types of boots.
Yes, I'm generally just comparing the outsole of the boot, not the style or the upper.
Now, the black gelatin lifters and the super glue is ether, it's ether fuming.
Yes.
Those are both enhancers, correct?
Correct.
So you're using those to enhance whatever you can get on the overlays.
I was attempting to enhance or develop any impressions that were there or not visible.
And that would be, you're looking for individual characteristics.
I was looking for any characteristics.
Any characteristics. Referring to your report on page 2, the paragraph that starts with 1. The one right footwear impression on Exhibit 39 corresponds with the 3 class characteristics with the right boot in Exhibit 35, correct?
Correct.
And what you're saying by that is it could have been made by that boot.
Correct.
So it's not an identification, but it could have been made.
That's correct.
And this was in your hierarchy of conclusions. This was, I guess, number 4.
It's in the middle.
In the
yes.
middle. So an association of class characteristics.
Correct.
And all class characteristics were made on this one.
Correct.
And then that the known footwear is a possible source of the question impression. So it's still possible.
Correct.
Other footwear with the same class characteristics observed are included in the population. So that means other footwear with the same class characteristics would be included in this too.
Correct.
And that's really why we don't have an identification here, correct?
There's no identification because there is no individual characteristics or present in the impression.
All right. So we have class here but no individual.
Correct.
And in your writing a report, you're using words that could have been made or possible source, correct?
Correct.
Your next paragraph down, which starts with 2, the 2 footwear impressions, these have similar design features with the left and right Timberland boot.
Correct.
However, due to the lack of sufficient detail and clarity, a more conclusive association could not be made.
Yes.
So this is really one step below your conclusion in with regard to the 1 impression.
Yes.
So this is similar design features, some class, but not all class,
Correct.
and no individual.
Correct.
So we're still not at the identification conclusion yet.
No.
Now, you compared the left and right Timberland boot to the 3 partial impressions that we saw in the photos, correct?
Yes.
Now, there were also unknown impressions on the white sheet, correct?
Correct.
And you couldn't make any comparisons with that?
There was not enough detail for me to do a comparison.
So you can't get to class characteristics on those.
Correct. I wasn't sure what the impressions were.
All right, so we don't even know if they were from footwear at all.
Correct.
And now let's go to your February 1st, 2016 report. And correct me if I'm wrong, but the language you use in your 2 conclusions are very similar to what we just went over. Has all 3 class characteristics, but no individual characteristics.
Yes.
And your conclusion then would be that it's an association of class characteristics,
Yes.
not an identification.
No.
And the next one, the 1 partial footwear impression, is similar design features, doesn't have all. Judge, may I have a moment?
Yes, sir.
No further questions.
All right, thank you. Any redirect?
Yeah, just very briefly. I believe defense counsel was asking you questions about the footwear impressions that you concluded could have been made by the boots in question. And those were the conclusions that you had that had sort of the highest degree of association with the boots. Is that correct?
Correct.
And I think you referred to that would have been 4 on your range. That actually would be like number 3, would it not?
Depending on which way you start, from the bottom up or from the top
Okay,
down.
let's start from the top. The top is identification, correct?
Correct.
Where you have all your class characteristics and enough individual characteristics to make an identification, correct?
Yes.
And then the next one down is
A
what?
high degree of association or most likely made by.
Okay, there you have all of your class characteristics, plus maybe 1 individual characteristic, which gives you a degree of confidence, but not enough to say identification, correct?
Correct.
And then the next one down is where you have all of your class characteristics, but no individual characteristics. Is that right?
Yes.
And that's the conclusion that you made with regard to that you've already testified to, or with regard, I think, to 2 of the impressions. Is that correct?
Correct. To 2 of the footwear impressions with the right boot.
Okay. One on that 1 gelatin lift on the right-hand side of the photograph, and then the one on the carpet. Is that correct?
Correct. 1 on the plastic sheeting and 1 on the vehicle floor mat.
Okay. Thank you very much. Nothing further, Judge.
Anything?
Going back to the FDLE range of conclusions, we're at a 3 and a 4 here, respectively, correct?
Correct.
5 being most likely made by, and 6 being an identification with the known, compares and identifies with the unknown, correct?
Correct.
No further questions.
Okay. All right, thank you. May the witness be excused.
You may.
All right, she needs to leave all the exhibits behind. She doesn't walk away with any exhibit to make sure. You're free to go.
Thank you.
State's next witness. All right, folks, I need to spend a little bit of time with the lawyers to go over some matters that are just germane to our discussions. But it would be unfair to you to have you sit back there for a long period of time. So what I'm going to do is adjourn early for you at this time, ask you to come back tomorrow, same time, 8:45, so we can get started right at 9. And your microphone is off, and I can turn it on if you want to do it from there. Okay.
I believe that may I proceed? I'm sorry.
Yes,
To the
go
court.
ahead.
Thank you. I believe that we're at the stage now where the state is attempting to introduce recorded statements of Mr. Toledo.
I should have said that beforehand. I think the state has informed the court that the next witness would be testifying as to the defendant's statement to the police.
And I think their intention is to play the recorded statements that were first the subject of the long motion to suppress we had back a couple of years ago now, almost 2 years ago to the day, quite frankly. So I just want to make sure that before I go on to the current objections we have, that I put on the record that we object to any of those recordings being played as part of the motion to suppress that we filed back then and heard over a few days with testimony and with legal argument that we briefed the court on. So we object on that ground every time, okay?
Yes, sir.
And then today, Your Honor, I believe that before the state can go forward, we believe that the law requires the state to have made a showing of corpus delicti, which I don't believe they've done. In general, I want to cover these points with you with case law, but we believe that they have to show that there was a death, that it was at the criminal agency of another person or at the criminal agency of someone, and that the person is identified who has died. We believe that the state hasn't been able to show any proof of criminal agency of another. We don't believe that the state has been able to show any evidence to the elements of the crime charged in the indictment. So they have to show corpus delicti for the crime that they've actually charged and not in general. We believe that each element, and we believe the case law supports this, it's pretty black and white law, quite frankly, that each element of the crime is proved with substantial evidence. That's from the case law. We don't believe that there's been any proof of murder. We don't believe that there's been any proof of first-degree murder, which is the crime charged, one of the crimes charged. We don't believe that there's been proof of second-degree murder. We don't believe that there's been any proof of premeditation at all. They have to show independently that the charged crime was what was committed. And we don't believe that there's been any evidence of any of that that would support a finding of corpus delicti that would allow them to play any of the recorded statements. The case law I have starts with State v. Allen, 335 Southern 2nd, 823. Your Honor, this is the Florida Supreme Court case that's the basis of, which is the basis of corpus delicti law. If you go to the third head note, it says in the body of the case, it is a fundamental principle of law that no person be adjudged guilty of a crime until the state has shown that a crime has been committed. The state, therefore, must show that a harm has been suffered of the type contemplated by the charges, for example, a death in the case of a murder charge or a loss of property in the case of a theft charge, and that such harm was incurred due to the criminal agency of another. This usually requires the identity of the victim. A person's confession to a crime is not sufficient evidence of a criminal act where no independent, direct, or circumstantial evidence exists to substantiate the occurrence of a crime. The judicial quest for truth requires that no person be convicted out of derangement, mistake, or official transaction. Official fabrication. This rule does not require the state to prove a defendant's guilt beyond a reasonable doubt before his or her confession may be admitted. Indeed, as this court has stated before, it is preferable that the occurrence of a crime be established before any evidence is admitted to show the identity of the guilty party, even though it is often difficult to segregate the two. This is important here, Your Honor. The state has the burden to bring forth substantial evidence tending to show the commission of the crime charged. This standard does not require the proof to be uncontradicted or overwhelming, but it must at least show the existence of each element of the crime. The state's burden of proof beyond a reasonable doubt is a requirement to establish the defendant's guilt, not to authorize admission of a confession. Key part here is that it has to be substantial evidence, although it does not have to exceed beyond a reasonable doubt standard. That would not be appropriate. But it has to show, it must at least show the existence of each element of the crime. And in first-degree murder, those elements are in the jury instructions that we have been working with. The state has to show that the person has died, that the death was caused by a criminal act or criminal agency, and that in our indictment on the first two counts, that this was a premeditated killing. That's the elements. That's what you're going to read in some form to this jury. There is literally no evidence of premeditation in this case whatsoever. There hasn't been a showing of it at all. We would submit that there has been inference of death. This has been our issue since we began. There may be issues with proving death. The court believes that's been shown. Proving death has not proved murder. Murder requires the element of premeditation as it's been outlined in our indictment, and where count 3 is concerned, it requires a depraved act. It has not been shown at all that there's been any kind of depraved act or any act at all. And quite frankly, Your Honor, there hasn't been any showing that there has been any criminal agency of another. There hasn't been any evidence to show that anybody killed anybody. There's been evidence that shows that people may be dead, but there's been no evidence at all that somebody killed them, and whoever that was Mr. Toledo. There's been no evidence of that, and then there's no evidence of premeditation in the first two counts. We'd go on now to a case that I provided the court. I'm not sure of the pronunciation, but it's spelled Sciortino versus the state. It's cited at 115 Southern 2nd, 93. Your Honor, in headnote 4 of that case, in the body of the case, it says direct evidence of one offense may not be used as proof of corpus delicti for another offense. So if this court believes that some crime has been proven in our case, that evidence of whatever that crime was can't be used to show corpus delicti in any of the other counts. So if the court were to believe, and that's, I would just submit to you, if the court were to believe that corpus delicti has been met, the obligation by the state attorney has been met in count 4, which is the evidence tampering case. If you believe that's been done, it stands alone. It can't be used in its own to infer guilt on anything else. I'm sorry, it can't be used to infer corpus delicti on anything else. In this case, the following things are also outlined when it comes to the principles enunciated by the Florida Supreme Court at the time this case was published. It must be shown that the specific crime charged has been committed. The state has to show that the specific crime charged has been committed. That means the state has to show that first-degree murder and second-degree murder has been committed. They don't have to do an identification of Mr. Toledo yet, but they have to show that that's actually happened. Beyond the first element of first-degree murder, they haven't showed criminal agency, and they have not shown 1 ounce of evidence of premeditation. They have not shown 1 ounce of evidence of a depraved mind. They've shown evidence that these two people were having an affair. They haven't shown any way that that's led to anybody being killed over it. They've shown, perhaps if the court believes that they've proved death, they haven't connected the other elements to second-degree murder to that death. This state requires it must be shown that the specific crime charged has been committed. The second thing is it is not necessary that the corpus delicti be proved beyond a reasonable doubt in order to introduce a confession or admission. I've already said that. The confession should not be received in evidence unless there is some prima facie proof of the crime charged. The specific crime charged must be prima facie established, and it cannot be inferred that because some crime was committed, that the specific crime involved in the prosecution took place. To reiterate what I said, it can't be that if you find that something has occurred, even some crime has occurred, that because any crime was shown that corpus delicti has been met. That's not the law of corpus delicti. The crime charged has to be proven before the statements can be admitted. In Roe versus the state, Your Honor, this is a case in which this is what happened. Mr. Roe was paid taxes on an illegal lottery, supposedly illegal. He paid taxes on gambling winnings, and it was in the lottery. And the court said in Roe versus State, 84 Southern 2nd, 709, the court said in Head Note 4, the crime charged was a violation of the lottery law. From the evidence introduced prior to the alleged confession, there could just as easily have been inferred a violation of the bookmaking laws. It has to be the crime charged. And in this case, what the Roe court says is that it would be unreasonable to attempt to show that some form of a crime was committed and then attempt to infer that since some form of crime took place, then the specific crime charged was committed. Because it has to be the specific crime charged, you can't infer from anything else that you're allowed to find corpus delicti that way. You're not allowed to do that. Roe goes on to say that to make any presumption, it has to be based upon facts. Even before confession or admission of guilt can be introduced in evidence, there must be some proof that the crime charge has been committed. But Roe says that presumptions have to be based on facts. It is well established that the basis of presumption must be a fact, and that one presumption cannot be the basis of another presumption. The fact that a crime has been committed or corpus delicti cannot be established by a presumption. If there's not a fact to support the inference, then you can't make the inference. That's Roe. If we're here to say, look at everything that happened, you have to find by circumstantial evidence that he's premeditatedly murdered someone, you're not allowed to do that because there's no fact of premeditation. There's no fact of criminal agency. There's been literally no proof, not any, that shows Mr. Toledo murdered anyone. What's going to happen now is that the state wants to play his recorded statements to do that. And to do that, they have to have proven in advance all the elements of the crime. They haven't done it. And you can't presume to do it without a fact to base the presumption on, and there's just not any. So Roe says that it's well established that the basis of a presumption must be a fact, and that one presumption cannot be the basis of another presumption. So we can't build this on what we presume from this to be the case. All of the evidence we're looking at, pictures and things, none of it goes to premeditation. None of it goes to criminal agency. It may go to tampering with evidence, but none of it's shown the murder element. And so we're asking the court to reject the request to allow them to play the statements. And then finally, Your Honor, I have MacArthur versus the state of Florida, 793, Southern 2nd, 1190. Now, MacArthur says that it reiterates a lot of the law that I've already told you.
Can I ask you a question?
Sure.
In reading Allen, by the way, I'm a little bit familiar with it. I anticipated this argument.
Yes, sir.
The corpus delicti rule requires that the state prove, and I'm kind of paraphrasing from the opinion, one, that a crime of the type charge was committed. What do you think the words that a crime of the type charge? Why didn't the Supreme Court just said that the crime charge was committed?
They did say. They did say the specific crime charged.
Okay.
They've said it over and over again. The elements of the specific crime charge must be proven, and that's in Allen.
All right. Okay.
Was that? I'm
That's
sorry.
it, yeah.
Okay. And then just reiterating from MacArthur. MacArthur says that it requires the existence of corroborating proof that an offense has been committed before a defendant's confession can be admitted. The rule is designed to ensure that no person be convicted out of derangement, mistake, or official fabrication. Florida has followed the majority rule in holding that corpus delicti of a crime is the body, foundation, or substance of the crime, which is generally said to include two elements, the act and the criminal agency of the act. Recently, however, this is in MacArthur at page 1193, which is under the head notes in the body 2, 3, and 4. And it would be on page 3 of the numbered page 3 of the case I gave you. Recently, however, the Supreme Court of Florida has also suggested that proof that a criminal act was committed requires proof of each element of an offense. For example, in order to prove corpus delicti, the state must establish that a crime of the type charged was committed, that the crime was committed through the criminal agency of another. In regard to the first part, that a crime was committed, each element of the relevant offense must be shown to exist, the relevant offense. With respect to the second part, the criminal agency of another, the proof need not show the specificity or the identity of the crime was committed by the defendant, not at this point. The state has the burden to bring forth substantial evidence tending to show the commission of the crime charged. The standard does not require the proof to be uncontradicted or overwhelming, but at least it must show the existence of each element of the crime. The state's burden of proof beyond a reasonable doubt is a requirement to establish. This is all citing Allen. And finally, it says a requirement that the prosecution adduce proof of each element of an offense may invite the conclusion that the state must offer proof of the underlying felony. This was about felony murder. So
Well, they're citing Allen. I mean, those words are verbatim from Allen.
Yes, sir.
What you're reading is straight out of Allen.
Yes, sir. I was going into the.
But the trouble I'm
specific-
having is in Allen, in footnote number 3, and I'll read it out loud.
Yes, sir.
For that paragraph. It is a fundamental principle of law that no person be adjudged guilty of a crime until the state has shown that a crime has been committed. The state therefore must show that a harm has been suffered of the type contemplated by the charges. Parentheses. For example, a death in the case of a murder charge, or a loss of property in the case of a theft charge. And that's what's throwing me off.
That's one of the elements. So they didn't list all of the elements, but they listed one of the elements. They have proved a death, but each element of the charge means they have to show the other elements. So if you can do it either way. You can say the elements of corpus delicti. So the elements of corpus delicti are death, criminal agency, and identification of the person that passed. Those elements. So if you say those are the elements of corpus delicti, then the second element of corpus delicti is not proven whatsoever. There's no showing that Mr. Toledo is or anyone, quite frankly, which is what they have to show, that the person died of criminal agency of another. There's no showing at all of that element by any evidence, not any. We've allowed evidence in that shows that evidence what's purported to be evidence has been moved or hidden. It's been tested. It's been found. There's no criminal agency of another in that element of corpus delicti, Your Honor. There's just not. There's no evidence of it at all. And the specific elements of the charges, if you go to that, then there's no evidence of premeditation. There's no evidence at all of that whatsoever, or to the third element in second-degree murder. But in the elements, I believe that Allen is talking about the elements of corpus delicti, the three elements.
I think there's another case, RLB versus state.
I have it.
Okay, which is 703 Southern Second, 1245.
I have it. Would you like a copy?
And that, in turn, requires the state to, quote-unquote, at least show each element of the crime before the defendant's confession is admissible.
That's true.
That's the premise. Okay?
Would you like a copy of it? I'll cite it for the record if the
No.
court would like.
I already did.
Okay, thank you. So we're asking the court not to allow the statements in, Your Honor. We don't believe they meet the elements of corpus selecti, and we don't believe they've been proven. Thank you.
Okay? State?
Thank you, Your Honor.
Yes, sir.
Your Honor, we obviously disagree with the position taken by defense counsel to submit the state has proven the corpus delicti in this case. I would note, just sort of as a side note, the statements are not really admissions. They're statements. And I had come across some
Are you saying the admissions are not confessions?
I'm not going to really make I'm just going to note it for the record because there were some cases that I had read that seemed to make that, but I don't know that I'm convinced that makes a difference in this particular case, but I always wanted to note it for the record.
I am aware that there is a distinction between an admission and a confession.
Right. But be that as it may, Your Honor, we still believe that we have proven a corpus delicti in this particular case sufficient so that the statements by the defendant, whatever they would be classified, are admissible in this particular case. I also disagree with defense counsel's argument that sort of seizes on the language in Allen that each element charged in the indictment there must be some showing of that to meet the corpus delicti. Commentators have actually noted that some of this language has actually been confusing, but if you look at the cases in its totality, when we're dealing with, and a lot of the cases that defense counsel cited are not murder cases, and they're not no body cases. When you look at the number of cases that are out there dealing with murder cases and cases without the body, you'll see that the three elements that have already been discussed are the elements of the corpus delicti, and Mr. Dean did mention those. Number one, in order to prove the corpus delicti, the state must establish three things. Number one, the fact of death. Number two, the criminal agency of another person as the cause thereof. And number three, the identity of the person. I have provided the court with a number of cases, and all of these cases are murder cases in which a body was not recovered. The first of which is Crane versus State, which is found at 894 Southern 2nd, 159, which is a Florida Supreme Court case decided in 2004. Myers versus State, which is also a Supreme Court case decided in 1998.
97.
Sorry?
1997.
I'm sorry, you're right. 98 was the year in 85. And Stokor versus State, spelled S-O-C-H-O-R, found at 119 Southern 2nd, 285.
619.
619.
Yeah.
Southern 2nd, 285, decided in 1993. And Barrow versus State, found at 27 Southern 3rd, 211, decided by the Florida Supreme Court in 2010. All of those cases go through those elements.
I have one more in my packet. Jefferson versus State,
Yes,
128 Southern 2nd, 132. Want to make sure opposing counsel has a copy. Okay?
And all of these cases analyze the facts that the state, the evidence that the state has presented in that case in order to determine whether or not the state had proven a corpus delicti prior to defendant's statements being admitted into evidence. Many of the things that were considered in those cases, for example, in the Crane case, and I won't get into all the facts, so we'll be here for quite a while. This is a case of a 7-year-old child that had disappeared. The defendant was charged, and there were circumstances in that case. He was the last person in the presence of the victim. Her blood was found on clothing of his and in his home. Scratch marks were found on his body consistent with fingernail scratches. He had bleached his bathroom in the middle of the night, and there was some unusual behavior on his behalf following the next morning. In Myers versus State, this was a 14-year-old girl who disappeared, and facts that the court found important in determining whether or not a corpus delicti had been made was that she had a good relationship with her grandparents. She had never expressed desire or intent to run away from home to any friends. She was looking forward to high school because she had made the dance team. She had asked another friend if she could spend the night with her. Defendant exhibited physical injuries consistent with violent confrontation.
Skip over all this. Tell me exactly what you think the facts are in this case.
Be happy to, Judge.
Yeah.
If you look at the three elements that the state has to present evidence concerning to show the corpus delicti, I'll just start with the first one, which is the fact of death. I have written down 15 things that the state has presented evidence of in this particular case to demonstrate, and as Mr. Dean accurately said, we don't have to prove these things beyond a reasonable doubt. Number one, there has been no contact from the victims in this case to any family or friends for more than 4 years since their disappearance, despite a previous history of daily contact with family and friends. Number two, the victim's family was very large and very close. The victims would not have left, according to testimony that was presented, would not have left without talking with someone. Number three, as we heard today, there has been no substantial activity on Yesenia Suarez's bank accounts or credit records. There's been no new purchases. There's been no money withdrawn. The only activity essentially are paychecks that she had previously earned being deposited into her accounts, a tax return being deposited in her accounts, and then maintenance fees in her account. There have been no credit cards that have been taken out, no purchases made on those that she held. Number four, the children who were in school at the time never returned to school. And the school, as we heard from Mr. Nathan, the principal at their school, has never received any request from any other school for their school records, which is a common practice. Number five, Yesenia Suarez had a good job. She was considered by her superiors to be an excellent employee. She didn't resign. She wasn't terminated. She simply left work that day on October the 22nd, 2013, and never returned. Number six, she was attending college and was just months from her graduation with her bachelor's degree. We heard testimony from her mother about what a significant event that was for her. She didn't really consider her associate's degree that big a deal, but she considered her bachelor's degree to be a big deal, and that was just months away. And she missed her graduation. She missed other substantial events in family members' lives, such as birthdays, holidays, that she had never missed before. Number seven, her car was left behind. Number eight, her purse was found in the car with her wallet, her identification, her insurance card, and a checkbook still inside. Her cell phone was found in the car. She left behind a household full of possessions, including family photos, clothes, luggage, backpack, toiletry items, computers, electronic devices, toys, furniture. She basically left everything behind. She took nothing left with her. Number 11, we heard testimony from neighbors from across the street who heard a female scream, "Help me," several times late in the night, and that those screams came from the general vicinity of the house there. Number 12, we heard testimony from Josh Moss that there were, and from Leroy Parker, multiple impact and cast-off bloodstains were found in 3 locations in the defendant's bedroom and bathroom. And according to testimony from Leroy Parker, that these are 3 forceful bloodshed events that get lower in height as those things move into the bathroom. And the last bloodstains in the bathroom were deposited on or near the floor. We heard testimony today that those bloodstains from the bathroom, many of them, were found to match the DNA profile of Talia Otto, one of the victims in this case. We heard today that Talia Otto's blood and DNA were found on a pair of boots, on the defendant's boots, and a trunk mat found in the dumpster. And also, these children, when you look at the children beside themselves, they're too young, Your Honor, to voluntarily disappear or survive independent of one another, independent of someone to take care of them. Looking at the second element of the corpus delicti, the criminal agency of another, I have noted, again, 15 things that we have presented in this particular case that prove that element of the corpus delicti. Number one, the defendant discovered that his wife, Yesenia Suarez, was having a coworker with an affair with a coworker, giving him motive for her to disappear, for him to have murdered her. Number two, their marriage. We heard a lot of testimony. Their marriage was deteriorating in the days and weeks prior to that. Number three, that they had been involved in verbal altercations during the time of Yesenia Suarez and her children's disappearance. Number four, family members and friends were aware that Yesenia Suarez had informed the defendant that she wanted a divorce within days of her disappearance. Number five, the day prior to their disappearance, the defendant angrily confronted Yesenia Suarez and her coworker at work about the affair and insisted on informing her employers about that affair. Number six, the night before, the defendant and Yesenia Suarez had another argument about the affair at Yesenia Suarez's mother's house. Number seven, the defendant solicited a neighbor or friend to help move his wife's car to a grocery store parking lot in another county. Number eight, he was seen by that same person suspiciously wiping down his wife's car with a rag and a bottle of cleaner after parking it in the parking lot of the grocery store. Number nine, he was seen removing items from his wife's car and placing in his own. Number 10, he dumped the truck mat and from his wife's car, his boots, the bottle of cleaner used to wipe his wife's car down, his clothes with the garage door clicker that we learned today had his DNA on it, and other items into a dumpster at an apartment complex. We heard testimony about those boots, that they were his size. We heard testimony from, I believe, Josh Mott about that during this case. And again, Talia Otto's blood was found on them. Number 12, again, as I just mentioned, the garage door clicker that was found in the sweatpants dumped in the dumpster contained the defendant's DNA. Number 13, he dumped his vacuum cleaner and stuffed animals in another dumpster. Number 14, the first responding officers that came to the scene of the defendant's home on the morning of October 23rd, 2013, all smelled an overwhelming odor of chemical cleaning agents such as Pine-Sol immediately upon entering the defendant's home the morning that the victims were reported, that their disappearance was reported. And we also know, just from opening statements and being familiar with the case, that efforts we made to blame this on Shawn Jackson. There's been no evidence of his fingerprints or his DNA being found on any of these items of evidence. And then lastly, the identity of the deceased, Your Honor. We've heard testimony from Felicia Perez identifying that it was her daughter, Yesenia Suarez, and her grandchildren, Michael Otto and Talia Otto, were the individuals that disappeared. And again, we heard DNA evidence today indicating that Talia Otto's blood was found on several items of evidence. I don't even think this is, forgive me for stating a personal opinion, but I don't even think this is a close call. The evidence is overwhelming when you consider those three elements that all of these cases, these are the elements they must present evidence to show, to present a corpus delicti in order to have a statement be admitted into evidence. So again, I don't even think this is a close call, Judge. As you've already pointed out, it was from the Allen case, and I believe all these cases that I provided before provide an explanation in a better way than I can argue it. But it's not the exact crime charge. What the cases make clear is that it is, as you have already pointed out, Your Honor, the state has to show that a harm has been suffered of the type contemplated by the charges. For example, a death in the case of a murder charge, or loss of property in case of a theft charge, and that such harm was incurred through the criminal agency of others. We have met that burden, Your Honor.
Okay, thank you. All right, your response. You get the last word.
Here's the, I just got the cases, so I just want to make a comment on a couple of the cases to
Yeah.
distinguish them. The case Crane, 894 Southern 2nd, 59 is a felony murder case, Your Honor. The case that I gave you a case in which it dealt with felony murder, in which it says that the underlying felony of felony murder is not required to be proven, but the same elements apply. So the same elements apply. So in the Crane case, which was provided by the state, the facts sound like this. Circumstantial evidence was sufficient to show the child victim was dead and that the defendant killed her, as required to establish corpus delicti, despite the evidence the child's body was never found. The child was last seen in defendant's presence at mother's home. Child's blood was found on defendant's boxer shorts and the toilet tissue and toilet seat in the defendant's bathroom. Scratch marks consistent with child's fingernails were found on defendant, and defendant bleached and scrubbed the bathroom for several hours. The assumptions that are being made when it comes to criminal agency are the kinds of things we've been worried about since this case started. We go from having a well-kept house to it being a murder scene because it smelled like pine sol. That's not evidence of anything. It's not evidence of criminal agency because there's no evidence of who these children were last seen with. There's just not any. And so if you go by that...
I'm sorry, maybe I misheard, but I thought the grandmother said that she left with the children.
She did. And that's... So the evidence, I'm agreeing with you. The last evidence of anybody saying they saw the children, they were with their grandmother and their mother. And so I don't know how we get from them being alone with the defendant, which is this Crane case and several of the other ones, to saying that we have evidence that they were last with Mr. Toledo. The only way you're going to get to that is if you play his statements, which...
I have to tell you this. I know that we can parse out each individual piece and say it's insignificant. But if you look at the larger picture and take a step back, and I think there seems to be a lot of circumstances here that kind of tie each other to one conclusion.
Well, they would be conclusions of possibly the element of death. But, Your Honor, there is no evidence if these children were killed, if they were killed by accident, if they were killed at all by anybody that's involved in this. And I'm using exaggeration as a point. I'm not trying to insult you. But what I'm saying is that, yeah, we will parse it out because we have to. And when we parse it out, when you go down however many things he said, none of them show that anybody in the universe committed murder. They show that evidence was tampered with, which is one of his charges. They show nothing else. When you get handed a case like this, and it says, like most of these do, that the defendant, the victim in this case, or any particular case, was in the last scene in the presence of, and in one of the cases, the defendant was sitting on top of somebody injuring him. This isn't the same case that we have. And you can list all of those things. You can list all 600 of them. But you don't get to the element of criminal agency independently. There's nothing there that says this is how they died. This is what's charged. This is how they died. And when I say criminal agency, I mean they died by a criminal act. There's no evidence of that. There's evidence of evidence tampering. But when you get to the second element of corpus delicti, there's no evidence of it. And when you're going to get evidence of it is if the statements are allowed to be played. That's the only time that anything gets connected, because without those statements, none of this will be connected. They won't be able to show any kind of the other elements. They won't be able to show premeditation. They won't be able to show the elements of second-degree murder. They're just not. it's not possible to do that based on the evidence that we have. So we believe that the statements should not be admitted because corpus delicti hasn't been made. You can list however many of those things on the list are the same thing. I would disagree with one of the things that was said. The cell phone was not found in the car. The wallet for the cell phone was found in the car, not the cell phone. So I would just say, Your Honor, that we don't believe that corpus delicti has been made.
I may have heard that wrong, but I thought the cell phone was in fact found.
There's pictures of it. You can see that it's empty.
I guess there's a disagreement. My memory was that one of the things that wasn't mentioned was teenagers across the street hearing somebody screaming, "Help me."
They did. They don't. They
I mean,
thought
that's
it-
one more circumstance that I was thinking,
Well, he.
when added to the grand picture of what we have.
Mark said he did say he did mention that they did it, but we don't know if it was the neighbor kids or not. The kids that heard it didn't know if it was the neighbor kids or not.
Right.
So
Okay.
that's our position in it. So we don't believe that they can do it. Thank you.
All right, I'm going to go ahead and authorize the presentation of the testimony, finding that the state has presented sufficient circumstantial evidence of the crimes alleged in the information. Is there anything else we need to address? Yeah. Mary has to go pick up her child. Is there something we can do in the morning?
Yes.
Okay, then let's come back at 8:30 tomorrow morning. All right, we adjourn. All right, Mary.